Hello, this is Janice Switlo. Today I'm going to discuss TLE, Treaty Land Entitlement. And this is the sort of information that typically in the information meetings that are held prior to the ratification vote, settlement, that are not discussed. So I encourage you to review this to allow yourselves a better opportunity to consider the kinds of questions you may ask at the information meeting, or alternatively, if you've already had your information meetings, then consider what was not discussed. Because, as I said, what I'm about to share with you is not typically what's discussed. A little bit of background: I'm former Department of Justice in-house legal counsel for Indian and Northern Affairs, and in that capacity, I was advising on specific claims on the West sector, West region. And a TLE, although I did not work directly on those, are simply a form of the specific claim under the specific claims policy. Now, one of the most critical things to appreciate is that in these TLEs, if you look at the treaties, they are not, you do not see in there that here's a certain amount of land you will reserve out of the permissions granted to the Crown based on how many of you there exists today. It simply states the quantum of land that you will select that constitute reservations out of treaties. That's where the term reserve comes from. It's a reservation out of treaty. What does that mean? A reservation out of treaty means this area our treaties do not apply to, in the sense that the Crown has no permissions in these lands. This is something we're keeping out of the treaty, so our full jurisdiction exists there. We're retaining this and not providing permissions. So again, when you look at the quantum and you look at the discussion of per 5 people, per family, that type of thing, you will not see it stating as at this date. I then interpret that to mean that at any given point in time, that's the amount of land that you will have reserved out of the treaty. Keep in mind, when these treaties were done, the attitude of those in Canada after the treaties were done was that you would be extinct soon enough. You would die out. Instead, what the timing of the TLE happened, you're actually expanding. And so I say the treaties represent that at any given point in time, you're entitled to that amount of land to be kept out of the treaties as you select. That means that if you double your population instead of at time of treaty, you're entitled to a lot more. But as a matter of policy decision under the claims federal policy, they dictated that the numbers will be restricted to how many of you existed at the time the treaty was entered into. So right off the bat, and remember, as opposed to the treaty being a living, continuing document that's intended to protect you and provide areas of your land, remember, when you entered into treaty, you did not sell your land. You were simply granting a lease, if you will, to the Crown to have permissions beneath your continuing ownership. You'll see those words to have and to hold. Those are boilerplate, standard legal terms that represent and make it very clear this is a lease, this is not a sale. So instead of it being a living document that always provides for your next generations, under a TLE settlement, you are restricting it to a one-time deal, and it's based on the numbers that existed at the time of the treaty. So that's an important thing to understand. This means that once the TLE is settled and a release is issued to the Crown, there is no more going back and saying, well, hang on, our population is now 10 times the amount, say 50 years from now. We need more land. You're not going to be able to get that because you've signed off and said, we've gotten everything we need forever. So I, on that basis, have an issue with TLEs. Second point is that specific claims are usually pursued when there is no, when the Crown and Canadian government can say, there's a statute of limitations that applies. You never came forward with it in time, therefore you're precluded under equitable principles from seeking a satisfaction of this today. Well, the point of the matter is the treaty is not set in time, it's a continuing relationship. And under those, and again, lawyers in Canada have never considered this point to my knowledge. It's a continuing document with your continuing needs requiring to be met. In this case, we're talking about reserve land quantity. Then you're entitled to say, wait a minute, this wasn't something that was supposed to take place in one point in time. It's a continuing obligation. Therefore, failing to provide us with what we request and require, that's a continuing tort. In other words, that's a continuing breach. So statute of limitations would not apply. Again, these are not, these kinds of arguments that are based firmly in law have not been pursued. Instead, settlements have been pursued. And usually, the lawyers and negotiators involved on that side are anxious to settle because they get 10% off the top of the settlement to be paid to them, and lawyers are actually sometimes taking more than that. So it's a continuing obligation. I say statute of limitations don't apply. Where do you go to do something other than a specific claim, titled a Treaty Land Entitlement claim? Well, we're not there yet because everyone has basically jumped on board on this. So the other, getting to the terms themselves, if it's decided to give up your entitlements for all time to be based on a historic population, if you do decide to go that route, you're given not lands, you're given money. Now, the critical issue about any settlement is, remember, at this point, it's an adversarial process. The Crown and Crown lawyers are not there as fiduciaries for you. They're not protecting you. They don't have to. They're your opponent. So they don't care, quite frankly. They used to, but they don't now. They don't care what happens with that money. If it gets blown, if it gets taken, if it gets converted into the hands of a few, Canada knows they won't be sued for that. They won't be liable for that. So instead of requiring that the monies be paid in a structure that would be protected and used only for the best interests of the people as a whole, these tend to get handed over. The lawyers take their cut. The rest gets put into a trust fund, or not necessarily having to go into a trust fund now under the policy. And you'll end up having a couple of people with no checks and balances having access to a lot of money. Now, theoretically, under what they'll say is, we're going to use this money to buy lands and then apply to have it set aside as reserve. You need to know that the federal policy regarding additions to reserve is to restrict and try to prevent, quite frankly, any more additions to reserve. Because remember, the whole idea is to try to get rid of the reserves. Eventually squeeze you, the poverty issues, everything else that happens on reserve, encouraging people to leave. And if ultimately everyone leaves, then those reserve lands become provincial lands. So there's huge incentives here to get the federal crown covered off and get these lands eventually into the hands of the provinces and get you out of position and out of place. Of course, when that happens, treaties fall too, because there's no more nation, there's no more party on the Indigenous side to the treaties. So, if you're going for this settlement and it's large amounts of money, you want to make sure it's going to be protected. You want details. And before you decide to approve and ratify this settlement, you want in place the structures to protect that money. And that's not something the general lawyer or negotiator is necessarily best qualified to do. And now, because of how the federal government has behaved recently, we know they're very keen, if the opportunity presents itself, to freeze bank accounts, for instance. So now, parties receiving large funds like that may well want to park them offshore so that they can't be subject to any allegations that could flow. So for instance, if you have a band who settled a TLE and they are very strong on who they are and decide to pursue things on that sovereign basis, they might be identified as a threat because this is not the agenda that Canada wants. They want you under self-government, under Canadian governments, considered a Canadian government. So for example, the recent development on that aspect of where things are going is that Canadian courts are determining that band councils are actually subject to the Charter of Rights and Freedoms. Why? Only Canadian governments are subject to the Charter. That means the courts are considering the Chief and Council, which have already years ago been decided to be a federal board, they're actually part of Canadian government. So again, if you have desires to say, okay, well, this is the best we can do right now, but we want to apply these funds to further our future existence in a positive Indigenous nation way, you're going to run into some trouble. So where's the money going? Who's going to handle it? What's the structure? Who's setting it up? Who are the trustees if that's the vehicle taken? If it's a sovereignty wealth fund, how is that structured? Who's in control? How do we make sure that individuals cannot convert those assets into their own holdings? You simply have a company set up and the money goes in there, or the money just goes into the band council, the band account. Everyone knows it's very hard to have any real accountability in terms of where monies have gone. And there have been settlements where the money is gone. And we're talking about millions and millions of dollars, and it's impossible to trace. So you need to have those protective mechanisms in place so that if you do decide to settle on this basis for all time, then that money's going to have to last. Now, back to additions to reserve. Ideally, it says, okay, we're going to buy land and apply to have it added to reserve. Well, what's happened in the past is that Chief and Council have been advised, it's much better to keep this in fee simple. Remember, when you're buying the land, you're not getting your land back, so to speak. You're buying interest in this land that has been created beneath the Crown's interest. And remember, the Crown's interest is all beneath your ownership. But what you're doing at that point is you're looking like you agree Canada owns it all through the Crown. And you're then opting into that real estate property rights scenario. As opposed to Canada purchasing the identified lands that you wish to have added to reserve, and then paying and buying it out from the owner, and then eliminating the fee simple estate structure, and then adding it to reserve. So there was a very easy way to do this if Canada was indeed intent on, good intentions towards increasing your reserve base. So you'll be told, it's in the city, you can make more money, keep it fee simple, etc. Well, that fee simple title, again, how is it bought? It has to be bought through a Canadian corporation. As opposed to, if Canada clears the title, it gets handed back and it becomes band reserve land. So, very important issues there. The other aspect of TLE, apart from you can't come back, how do you protect the money, is are you being given full information? Are you actually getting the entire agreement, or are you just getting a summary? There's been a bad practice of late where, they won't understand the agreement, so we just give them the main terms. This is the amount of land we're getting, this amount of money, or this is the amount of land that we feel we're entitled to as of our historic numbers. Here's the kind of money we're getting, etc. And it's very basic. You are entitled to see those agreements. And if those agreements do not have a couple of pages of serious legal terms regarding how that money's handled once it's paid out by the feds, then you really, quite frankly, should consider that money gone. And the other thing that happens, and I don't know if it's still happening, but the TLE settlement agreements have had sunset clauses. And it's shocked me that bands weren't even aware of that. Their lawyers didn't even apprise them that you only have a certain amount of time in order to add to reserve, to have it completed. Well, Canada controls the whole additions to reserve process. And as said, they have a specific policy to not let that happen. They don't want to create more reserves. So they just sit on it and delay. And it's ridiculous. Where's your lawyer? Why would you allow all that control within the hands of the government and the one party? You have no control over that. They can delay until you run out of time at sunset, and then you can never get it added to reserve. Now, all of these things require a specific look at the settlement agreement itself. As I said, many bands, the people have not had access to that, so they can't then take that to someone to have them look at it. Now, most band members also don't have money to pay for a lawyer to look at this and say, what is this? And those lawyers have said cannot necessarily identify the issues that exist because they don't see you as sovereign nations. They don't see the treaties as international agreements between nations. They see and have been bought in and trained to look at you as, these sort of domestic entities created under Indian. Because keep in mind, who can bring the specific claim, who can bring the TLE? It's an Indian Act defined ban. It's not brought on a nation basis. So as said, there has been no effort to try to resolve and pursue the amount of land you actually should be having set aside as reserve under treaty. That can only proceed on a nation basis. So those are my cautionary tales. It's important to have that document, to actually have someone like myself, for instance, who can take a look at that and say, well, here's the serious gaps, here's the dangers, here's what you're giving up, here's what you're handing over. How do you know you're going to get anything out of this? Will there be money left? Or will it be sunk into a company that will start up a business that chief and council, or just a few of them, or one of them even, controls through a company, and the money goes in there, and it's subject only to management standard of care, which is nothing. It's not a fiduciary at that point. Lots of issues, but you're not generally told those sides of the issues during the information sessions. You're basically only told, here's the deal, and here's when the vote is, do you like this or not? How can you make an informed decision? Full information is needed prior to making that decision. I submit that there has not been full information provided, that many bands members have actually been taken advantage of. That there's a lot more to be had in this situation, but it's not easy. TLE made it easy. The leaders in place at that time said, yeah, sure, let's do this. And what consideration did they receive at that time in order to see these things start up? So I'll leave you with that. I wish you well. I know there's one vote on this coming up. There's an information meeting today, as a matter of fact. I hope that this will assist those particular people who approached me at this time, and encourage you to not rush it. If it's a good deal, it's there. You need more time. You can vote it down. You can go back and say, okay, we need amendments to this agreement. We need to provide for security for the money. We need to make sure that it's not just the feds that control whether we get these additions to reserve. And that's all I have to say.